Hello everyone, you are welcome in this online Swayam course that is Understanding Competition Law Theory and Practice. I am your instructor Dr. Mayank Pratap, Assistant Professor, Faculty of Law from Banaras Hindu University. We will discuss the Understanding Competition Law Theory and Practice this course from today, the second module. Second module, we will start with our lecture number 6, that is the lecture number 1 actually of this particular week 2. Before this week, in last module, that is module 1, what we have discussed, the basic element key concept of competition. And in second module, we will have 5 lectures which will cover the origin of competition law, MRTP Act 1969, major development of competition law of India, with the objective to understand the origin, growth, development at global level and in India, to discuss the MRTP Act and to discuss the object of Competition Act 2000. So, with this, we will take up the whole module as a origin, growth, development and key concept of MRTP Act as well as Competition Law Act, that is Competition Law 2002. So, with this we will start, but having a snap on the previous lecture. The previous lecture that was particularly consist with 5 lecture in module 1 in particular week 1, and under first module what we have discussed, that is what is competition, what is the meaning of fair and unfair practices, why competition law needed, and what is the nature of competition law. And in last lecture we have discussed the Constitution of India, that constitutional value, and the Competition Act, the element of Competition Act, how both are interrelated. So, before we will start the second module, the second week, today's lecture, we have just to remind you that competition means a occasion or a event where multiple firms rivalry to strive to achieve some common goal, where they compete with struggle, and particularly the environment of business. In a business field, you can say the struggle or strive or fighting between the firm to attract more and more customer towards their product and services. We have also discussed to achieve this competition, sometimes the competing firms, company, individuals or people adopted the formula like fair and just formula, but sometimes they adopted the unfair means like restrictive trade practices or disruptive practices like. So that competition law or any antitrust law encourages or to promote the competition, and which only and only the fair and just competition. So, with this competition law is a set of regulation. Competition law is embodied in the codified law just to promote competition and to prohibit or restrict the anti-competitive practices, what we have already discussed in module 1. So, with this, in last lecture, if you remember, what we have discussed, how the impact of the constitutional values or the constitutional norms on the policies of the competition policies, and to execute that competition policies, what competition law or competition act we have, that is a tool by which we have to follow our constitutional norm, our vision, which reflect in our competition policy as well as competition law. So, with this, if you say the introductory part, the legal framework that ensure fair market, forces and prohibits anti-competitive behavior is known as competition regulation. The first example of competition law were found in the Roman Empire, where Roman lawmaker closely examined the government and traders' commercial operations. Throughout the Middle Age and the British Empire, the competition regime continued to expand. The Development of competition jurisprudence in the United Kingdom was largely based on the doctrine of restraint of trade, and the competition law has been adopted by many different geographical regions worldwide, and these regions have brought their economies under its provision. Competition law and policies gradually come to cover market failure, abuse of dominance, and the other bad practices in the form of anti-competitive policies. It is acknowledged that enforcing the competition law is a necessity from 1900 until the end of World War II. However, only 13 countries adopted the competition law. But during Cold War, another 28 countries adopting the antitrust law, that is competition law, and currently now 129 countries have framed competition law in the light or in the line of anti-competitive agreements prohibition, monopolies prohibition, or to regulate the merger and acquisition, or to restrict the fair trade practices. So, if we start with early competition law history from global output to domestic level, the emergence of competition law can be traced as the effort of Roman legislature to control price fluctuations and unfair trade practices. Legislation emerged under the Constitution of Gino of 483 AD. This could be traced to Florentine municipal laws of 1322 and 1325, which provided the strict action of any trade combination. The French Revolution is where the idea of being open to competition originated. Members of some corporations were forbidden from banding together to control their common interest by the Sherman Act of 1791. 20 years later, conditions were prohibited from manipulating price above or below the level that would have been determined by the free and natural competition by the French Criminal Code for 176 years. Article 419 of the Criminal Code remained in effect. If we try to check or the parameter on timeline of early competition law history, we can categorize it into certain steps. The early competition law history can be traced back to ancient civilization with significant development in the Middle Ages and Industrial Revolution. The ancient civilization, the time period of ancient civilization is 500 BC to 500 CE. Roman law and Greek city-state. Roman law, at the time of Roman law, if you try to find out or try to trace the element of competition law, actually that was not competition law, but having some inputs or some restriction or some gesture, you can say some element where you can find the element of the object of competition law or any antitrust law, where a state tried to regulate the competition or try to regulate the market, you can say. Under Roman law, the Roman Empire had law that prohibit unfair business practices such as price fixing and bid rigging. Again, in Greek city-state, some Greek city-states like Athens had laws that regulated trade and commerce, including rule against monopoly. If you come on Middle Age, that is between 500 to 1500 CE, there are some guilds. There are guilds. During the Middle Age, guilds played a significant role in regulating and commerce. Guilds were association of craftsmen or merchant that set rule for price, quality and market access. So there are, if in not only in Middle Age, but Middle Age in India particular, if you see the Indian continent, in India, the role of guild was very important, and you can find out the role and function of guild even in Arthashastra written by the Kautilya. So we will discuss in the stage where we'll have to see the history of competition, or we will try to trace out the history of antitrust law or competition law within in India, so that for till you have to see and struck on the general scope, and in middle age you can see the guild or the person or the significant association or players having in the merchant with related to the price economy to quality and practice access. And English common law, if you find to try out the English common law system which emerged during the middle age, included principle that prohibited under unfair trade practices such as restraint of trade. In the same line, that means in historical aspect of early competition law, if you come with another phase, that is the phase of industrial revolution, which is a very important phase. Industrial revolution is basically the phase which is actually the phase which is responsible for competition regime or monopoly act, or the act where act is required to curb the anti-competitive practices, because this is the time where industrial revolution has taken place. More and more competitors try to survive in the same market, and there is a huge fight. Fight does not mean a violence fight. Fight here means fight for rivalry to expand their market. So you can see the industrial revolution, the time of industrial solution, that means the time period between 18th and 19th century, there are two aspects. Laissez-faire economics aspect. The industrial revolution brought significant economic changes, including the rise of laissez-faire economics. The philosophy advocated for minimal government intervention in economic matter. That means at that starting age of industrial revolution, generally nations tried to structure their policy with no interference or minimum interference in market. So the policy that is called in a legal term or in a phrase, that is laissez-faire economics. And trust and monopolies. In late 19th century saw the emergence of large trust and monopolies, which lead to concern about their impact on competition and the economy. And in earlier competition law stage, if you comes on later stage, that means late 19th and early 20th century, you will found there are the time where some statutory provisions are came, where they have started, country has started to regulate the market, to try to regulate the market feature, to try to regulate the monopoly, and try to invoke the competition and provide a level field in the market. Some statute came, and particularly the US school, the United States of America's, the legislation of United Nations of America related to antitrust law is very much important. If you see in a practical sense, the United States of America's statute towards the antitrust law, each source of information is the first or primary source in the manner of modern competition law, which give rise the importance and which give rise to modern competition law, which start with Sherman Act. The Sherman Act 1890 of the United States, which is the passes the Sherman Act, which prohibit the agreement in restraint of trade and monopolization, was the first of its kind of modern antitrust law, you can see. And again from Sherman Act, if you see few years later, the Clayton Act came in 1914. The Clayton Act was passed in United States, which prohibited price discrimination, exclusive dealing, and merger and substantially lessened competition. And these are the acts, that means whether it is Sherman Act or Clayton Act, the acts were regulated to the USA or United States Act, but there is a one more act which you have to focus in history of for the purpose to trying to trace out the history of competition law, that is of German Institute, and the name of the German Institute is German Cartel Law 1923. German Cartel Law 1923 enacted its first cartel law which prohibited cartel in fact and other restrictive agreement. So the Sherman Act, Clayton Act 1914 and German cartel law is basically the concept which give birth to modern competition law. So it was the starting time of early competition law, and trying to face out the history. If you come to the later stage, that is after 19th century, starting of 20th century and in the mid of 20th century, that is not early competition law, basically in 20th century, the rise of the birth of the modern competition law in fact. And at international cooperation level, if you see, European Economic Communities in 1957. The Treaty of Rome established the European Economic Community, which included provisions on competition policy, and United Nations Conference of Trade and Development, which is popularly known as UNCTAD. In 1964, the United Nations Conference on Trade and Development adopted a set of principles and rules on restrictive business practices. The early competition law history laid the foundation of modern competition law and policies. Today, competition law is an essential part of our economic regulation, which is important or which is kitten at the promoting fair competition and protecting consumer worldwide. If you see the rise of modern competition law, you have to go again with 18th century, because it starts with the 18th century, and the basic concept of competition can be dated back in 18th century, were brought merely as an absence of any type of restraint on trade in legal term by Adam Smith in his book Wealth of Nation, which was published in 1776. That means you can say Adam Smith book Wealth of a Nation was the inspirational source which give rise or birth the concept of modern competition law. The theories and the principle enumerated by the Adam Smith was very important even today in regulating the competition law and modern anti-competitive practices to prohibit the any institute of antitrust law if there must be even not formalized, but one of the source, definitely the principle which was given by Adam Smith, which was published in 1776. However, modern economic theory can be dated back in late 19th century, particularly if you see year 1890, which led to the drafting of Sherman. We have already discussed here the Sherman Act, whether it is a Sherman Act or Clayton Act or German Act, was the modern institute which was the inspirational source or the first phase of the birth of modern competition law. So the drafting of Sherman Act in the US has become known as very first antitrust legislation. The Sherman Act of 1890 is regarded as one of the most turning point in the development of contemporary competition law. During the 19th century, when the Sherman Act was passed, industry was expanding quickly. Wealth accumulated in the hands of numerous corporations and individuals as a result of rapid industrialization. Additionally, it led to rapid advancement in corporate structure, which effectively increased the number of ways competitor could combine to avoid market competition. Under the basis of trust, partnership quickly expanded in a number of crucial industries, including steel, oil, and finance, with the intention of reducing competition. Their growing economic might spread widespread concern about public harm and individual operation. The Sherman Act was passed in order to dismantle these trusts and bring back market competition. an act to protect trade and commerce against unlawful restraint and monopolies. There are two sections which is important, and you have to analyze this section in the light of to find out or trace out the history of modern competition law, that is section 1 and section 2 of the Sherman Act. The section 1, every contract combination in the form of trust and otherwise conspiracy in restraint of trade or commerce among the sub-state or with foreign nations is declared to be illegal. And again in the same line, the section 2 of this particular act, where stated that every person who shall monopolize or attempt to monopolize or combine or conspire with any other person or persons to monopolize any part of the trade or commerce among the several states or with foreign nations shall be deemed guilty of a felony. As one may notice from these provisions, while section 1 prohibits the agreement that restrain trade, and on the other hand section 2 focuses on monopolization. There is a case of observed by the Honorable Supreme Court of United States, Standard Oil Company of New Jersey versus United States. This case presents a philosophy of antitrust law, philosophy or object of competition law, how it became important and why it is important. This case is particularly with relation in section 1 of Sherman Act, which is about the restriction on the trade and trade practices. If you see, the Standard Oil Company case is one of early case that clarified the scope and ambit of Sherman Act of 1890. It is also one of the cases that can clearly illustrate the historical concept of Sherman Act, and hence it is considered as a must read for all learner, all students. What you are learning here, this is very much important for all the person who deals with or who is interested in modern competition law, that is competition act, whether it is competition or act, any interest or economic law, you have to go with this case particularly. I recommend you. All student of competition law, this case was an appeal against the decision of a lower court, which had directed the dissolving of holding company for the violation of provisions of Sherman Act. The defendant in the case, if you go with the detail of the case, you will find the defendant in the case had formed the trust and enter into different anti-competitive practices and agreement to fix the price of crude oil, refined oil and various other petroleum products. They had also limited the production and distribution of those products to increase profit. In this case, the United States Supreme Court introduced the use of rule of reason approach and clarified that Sherman Act prohibits only contract and combination that amount to unreasonable or undue restraint of trade. Based on extensive analysis of the fact of the case and the relevant legal provisions, the court came to conclusion that the defendant in the case had imposed unreasonable and undue restraint on trade in petroleum and related products and thereby violated the provisions of Sherman Act. So this act was basically, that means this particular case was basically the philosophy of the Sherman Act. This case gives a light, it throws a light on the object, preamble and the basis of Sherman Act, particularly it is related to section 1 of Sherman Act, and this will give a light to the whole competition policy, that what should be the basic ingredient in a competition law or any antitrust law. So this is a very important case, you must go in detail with this act. So to address some of the Sherman Act flaws and to provide greater clarity on the precise business activities that are subject to the antitrust laws, the US Congress passed the Clayton Act and the Federal Trade Commission Act in 1914. Price discrimination, tying, and exclusive dealing contract were among the particular issue that the Clayton Act addressed. In addition to regulating merger and acquisition that could undermine competition or lead to monopolies in any market, the Clayton Act gave individuals a private right of action and permitted them to recover 3 times of damages they had suffered in addition to cost as legal fee. And later on, 2 amendments to the Clayton Act were made in 1936 and 1950. The Robinson-Patman Act of 1936 outlined the specific types of price discrimination. The historical background of this law demonstrates that the main goal was safeguard small-scale merchants who were in grave danger of going out of business as the result of large-scale chain stores that were procuring goods at steep discount. When goods of similar grade and quality are sold for consumption, resale, and there is a significant risk of reducing competition, creating a monopoly or harming, destroying or preventing competition, it is illegal to discriminate between price difference between buyer according to the Robinson-Patman Act. US antitrust law is guided by the 2 economic schools of thought, that is Harvard School and Chicago School. The Harvard School emphasizes structuralist principle advocating for strict regulation to prevent market concentration and monopolization. This approach influenced early US antitrust jurisdiction where courts were more inclined to break up large firms to promote competition. And the Chicago School, on the other hand, takes a more laissez-faire approach, arguing that the market forces or efficiency should guide antitrust enforcement rather than rigid structure presumptions. The EU, that is European Union, adopt a hybrid strategy that combines ideas from both schools. Although structuralist principles are important, European Union antitrust enforcement prioritize economic analysis and effect-based evaluations, especially in the cases involving abuse of dominance. Although India's competition law is still developing, both viewpoints are incorporate its framework. The Competition Act of 2002 case-by-case evaluations and shows a preference for behavioral remedies over absolute structural remedies. So with this, here we are at the end of this session and we will take up the next lecture with the topic origin of Indian competition law. So with this, thank you for this session. Thank you.